Start the recording. So hi, good evening everyone, and thank you very much for joining us this evening. We're delighted to be joined by Dayan Yehonoson Hool of the Federation based in. Dayan Hool joined the Federation in 2016 as a member of the Chartered Institute of Arbitrators and author of the book Based in Commercial Arbitration. For anyone who hasn't downloaded the source sheet, I have just posted it again in the chat. And without further ado, I'll pass over to Dayan Hool. Thank you very much.
Thank you, Aaron. Okay, good evening, everybody. We're going to discuss today, as we've seen, the title is Circumstantial Evidence in a Din Torah. So very briefly, first of all, a Din Torah is an arbitration in a Beis Din. The primary function of a Beis Din, historically and still today, is that it's a court of arbitration, which means a private court where two parties who have a financial or commercial dispute submit to the jurisdiction of the Beis Din. The Beis Din hears the case much like a court would hear the case. Witnesses are testify, documentary evidence is produced if there is any, and then ultimately the Dayanim issue a ruling, issue an award, just much like a court would do, and that award is binding on both parties in halacha. That's how the Jewish Beis Din system works, and of course it was set up in the times of Moshe Rabbeinu, possibly even before Matan Torah. It was Yisro's idea, and it's been a feature of Jewish communal life ever since, long before the court systems were set up in the secular society. Nowadays too, the Beis Din functions as far as English law is concerned, as a private court of arbitration. English law and most secular laws in most countries in the world recognize the concept of arbitration. The two parties with a dispute can go to a third party, an individual, a tribunal, submit to arbitration, sign up at the outset a deed of arbitration, committing themselves to whatever the tribunal says, and then the tribunal ultimately issues a ruling which will be binding. So nowadays, in a Din Torah, two people have a financial or commercial dispute, they come to Beis Din, they sign a deed of arbitration, the Beis Din hears the case, ultimately issues an award, and it's enforceable and binding both in Jewish law and lahavdil in secular law. So the subject we're going to discuss briefly this evening, without going into too much detail, is the concept of evidence in a Din Torah, or in a Beis Din arbitration, if you like. So if you look at the source sheet, the very first source that we have here is a pasuk in Devarim Yud Tes, pasuk Tes Vov. Lo yokum eid echod beish lechol avono lechol chatos, v'chol chet asher yechto. A single witness should not stand up against a person. Al pi shnayim eidim or al pi shlosha eidim yokum dovar. Through the evidence of two witnesses or three witnesses, a matter should be established. So if you have a look at Rashi there, the idea being that when a person wants to make a claim in Beis Din and he wants to prove it and he wants to bring witnesses, it's not sufficient to bring a single witness. You have to have at least two. You can have three as well, but at least two witnesses in order to establish the veracity of your claim. Now, in the absence of two witnesses, we would have to hear what the other party obviously has to say. And then there are all sorts of rules about how one judges a case in the absence of any compelling evidence one way or the other. But certainly if two witnesses come forward and say, we were there and we saw it happen. Reuven says, Shimon stole money from me. Shimon denies it. Two witnesses come along and say, we were there and we saw Shimon stealing money. We've established the truth of what happened by two witnesses, and we will find Shimon liable to repay the money to Reuven. So the Torah specifies, certainly when it comes to monetary matters, we need the testimony of two kosher witnesses in order to establish a fact. What happens if you don't have two kosher witnesses, but you have circumstantial evidence? You have the facts of the case which indicate a certain conclusion, but it's not testimony of two witnesses. So there are a number of different forms that this can take. And we'll start with the second source we have on the source sheet. It's a Gemara in Bava Basra, as you'll see, Daf Kuf Mem Vav on the base. It's immediately after the Mishnah, and the Gemara says, "Man tona to oslinon bosa umdana." Umdana, the concept of umdana is an Aramaic word, and the idea is it means a supposition, a strong assumption. Who is the Tana? Which is the Tana of the Mishnah who holds that we would follow ein umdana, a strong presumption. Reb Shimon ben Manasseh, Reb Nachman answered, it's Reb Shimon ben Manasseh. He is the Tana who holds that we would use a strong presumption in a din Torah. What's the example? The Tanya we've learned in a brisa. There was a man who had only one son, and the son traveled abroad. This man subsequently heard that his son had passed away. It was his only son. He had no other heirs, direct heirs. So he stood up, he wrote away all of his property to somebody else. But it turned out that the news was wrong, and his son was alive and kicking, and his son turned up, he came back. So the man said, well, in that case, I never intended to give away all of my property to somebody else. I would have obviously left something for my own son. So the Tana Kama, the first Tana says, Matana sa matana. His gift is a gift, it's a valid gift, and it can't be voided simply because he was mistaken and his son has returned. However, Reb Shimon ben Manasseh says, Ein matana sa matana. His gift is not a gift, it's voided. Why? If he'd only known that his son was actually alive, he would never have given away his property to somebody else. What do we see from the opinion of Reb Shimon ben Manasseh? We see this idea, this concept, that if we don't have absolute evidence as to what the man was thinking, we don't have two witnesses to testify what he was thinking. All we see in front of us is a man gifting away all of his property to a third party. But if you look at the circumstances surrounding this gift, we can discern with a fair degree of certainty what the man is thinking. The juxtaposition of the fact that the man was had heard that his only son had died, and then gave away all of his property, didn't leave anything for himself, gave absolutely everything away, is surely safe to assume and to presume that the reason he did this was because he thought he didn't have any heirs or close heirs left in the world. And the minute the son comes back and he's alive, it's clear to us all that, if you like, this gift was conditional. The man didn't express a condition. He didn't say, I'm giving this on condition that it's true that my son is dead. But the circumstances indicate that that's what he was doing. Any objective observer would come to the same conclusion, that this man was assuming that his son was dead, but had he known his son was alive, he would have never gifted away everything that he owned. Reb Shimon ben Manasseh says that presumption is strong enough that we are able to use that, to employ that in a din Torah, and we will void the matana. So here we see the concept of umdana, a concept of strong presumption, which is enough to allow the person to take that into account and to overturn a matana, even in the absence of the testimony of two witnesses. This concept is of umdana is found in a number of places in the Shulchan Aruch, which is the classic code of law of the halacha. A very good example of this is a person who gives away his property in order to prevent a creditor from claiming the debts. It's very interesting, actually. There was a case back in Elizabethan times here in England. It's called Twine's case. It's a very famous case of a fellow who owed money to somebody, and the court found him liable, and the sheriff was on his way to come and claim the money on behalf of the debtor, when the fellow quickly gave away everything that he owned as a gift to a friend of his who was called Twine, if I'm not mistaken. And when the sheriff came, he said, I have no more property left because I've gifted away everything that I have. The case went to the Star Chamber, and the Star Chamber decided that it was clear from the circumstances that this gift was not a genuine gift. He was only doing it in order to hide his assets from his creditors, and the gift was declared void. And there were several indices which the Star Chamber pointed to that indicated that it wasn't a genuine bona fide gift. Firstly, there was the fact that he gave away absolutely everything that he had, which is most unusual. No one gives away everything he owns to somebody else as a free gift. Secondly, the timing, the fact that it was just as the sheriff was on his way to make the claim. Thirdly, the fact that he was actually still using his property, even though he had supposedly gifted it away to somebody else. And fourthly, the fact that he'd actually written in the deed of gift that this is a genuine bona fide gift, which itself raised suspicion. Why would he find the need to write that? That itself was an indication that it actually wasn't a genuine bona fide gift. At any rate, that was a law that was a court case that was historically ruled on in England, and the basis of that court case applies even today in bankruptcy proceedings in England and in other common law countries. But curiously enough, a few hundred years before the Star Chamber came to this decision, the Rosh, that great Rishon, who was originally from Germany but had to run away and ended up in Spain, ruled in several tshuvas and several responsa almost identical psak. There was a case that came before the Rosh where a man owed a lot of money, and again he transferred all of his property to his brother or brother-in-law as a free gift. But then the Rosh says that it was clear that he was only doing this in order to avoid paying up the debt. And again, the indices were very similar. It was the timing of the gift, the fact that he gave away everything entirely, the fact that he was still using his own property, which he had supposed to have given away. The Rosh ruled that the gift was void, and therefore the creditors can claim from it. So again, we see this concept of umdana. We see in front of us what appears to be a bona fide gift, but the circumstantial evidence is so strong as to create a clear presumption that what we're seeing here is not on the surface of it as it appears to be. There's actually a different intention going on altogether. So again, although the Torah says when it comes to dinim ominous, we need the testimony of two witnesses, we see clearly from the Gemara here and other places and from the Chuvas and the Rishonim and from the Shulchan Aruch that occasionally an umdana, a strong presumption, is enough to actually help us into ascertaining the truth and taking a ruling on what the on the case. And briefly to refer to a Gemara in Kiddushin, a famous Gemara Kiddushin, which I haven't actually brought down here, about a man who sold all his real estate because he intended to go on Aliyah to Eretz Yisrael, and in the end didn't work out, and he was stuck in Europe. And this is going back in the times of the Gemara, stuck in Bovel. And he wanted to avoid the sale because he said, I'd only sold it on the understanding that I was going to move to Eretz Yisrael. If it doesn't work out, I want my house and my fields back again. So the Gemara clears there, discusses the sugi of dvarim shebelev einon dvarim. If a person has something in his mind, but he doesn't clearly express himself, and we normally ignore what he's thinking if he doesn't actually put it in as a condition to the sale. And Tosfos there in Kiddushin sums it up. And Tosfos says, it depends what type of presumption there is. If we have a very, very clear presumption, any objective observer would come to the same conclusion as to what the person's intention was, then it doesn't need to be expressed. Just like our case of Reb Shimon ben Manasseh. It's clear to anybody who sees that the man's giving away everything because he thinks that he's just heard that his son is dead. Surely, if he'd known that his son was alive, he wouldn't have intended to give it away. There are cases where it's not absolutely clear, but there is a strong indication that that's what happened. In the case of a person who sells his property, his real estate, to go to Eretz Yisrael. In that case, if he didn't express himself at all, then we would ignore what he might be thinking. But if he did express his intention to go to Eretz Yisrael at the time of the sale, even if he didn't actually explicitly make the sale conditional on him going to Eretz Yisrael, but he just said, I'm selling this because I'm going to Eretz Yisrael, that would be enough of a presumption, because it's unusual for people to sell their house and certainly in those days, to sell their house and their fields and any real estate and leave themselves with nowhere to live. So it's clear that the fact that he mentioned he's going to Eretz Yisrael is a condition, even though he didn't explicitly express it as a condition. And then we'd have a third circumstance where it's not clear at all what the person's intention was. Someone who perhaps was intending to go to Eretz Yisrael but sold his shettles, his movable goods, his metaltalin. For example, he sold his car, or in the tomorrow's times, he sold his livestock. People sell livestock every day. It might be that he happened to be going to Eretz Yisrael, but there's no presumption that he wouldn't have sold it had he not been going to Eretz Yisrael. So in that case, if he wishes to void the sale in the event that he doesn't go to Eretz Yisrael, then he's got to express explicit condition at the time that he makes the sale. He's got to say, I'm selling this on condition that I go to Eretz Yisrael, but if I don't go to Eretz Yisrael, I want the sale to be void. So we have various levels of umtana. We can't always use a presumption because it depends how strong the presumption is. If it's very clear as to what the man was thinking, we can use that presumption. If it's fairly clear, we can use it if he expressed this point, even if he didn't make it explicitly conditional. If it's not clear at all from the circumstances, then if he wants to make a condition, he has to clearly express the condition and make the transaction conditional on the thing on the contingency that he has in mind. So that's just to review the important Gemara in Kiddushin. Now we turn to a third Gemara. This is on the second page of the source sheet we have. It's a Gemara in Shavuos, Daf Mem Vav on the Beis. The Gemara is referring to a Mishnah. The Mishnah there says that normally, if someone makes a claim and the other person denies it, the onus of proof is on the person who's making the claim, not surprisingly. But sometimes the Mishnah says, even if the claimant can't prove it, if he's prepared to swear an oath in the Beis Din that he's telling the truth, then he would be believed even to force somebody else to pay up. There are very limited circumstances to this. The classic case in the Mishnah is Shvuas HaNechbal. Reuven comes to Beis Din and he's got a clear wound on his body. And he said it was Shimon who did it. Shimon denies it. So under certain circumstances, Reuven has no proof. He doesn't have two witnesses. But under certain circumstances, the Mishnah allows him to swear an oath that he's telling the truth, and it was Shimon who damaged him, and he would be able to find, and the Beis Din would find Shimon liable to pay damages to Reuven. So the Gemara is discussing this case of the idea that Reuven can make a shavua and end up winning, even though he hasn't got any other proof. So the Gemara there says, Nechbal Ketzad, this is the second line down. So Omar Rabbi Yehuda Mashmul, Rabbi Yehuda says the name of Shmuel, Lo shono ela b'mokem sheyochel lechabel ba'atzmoi. It's only necessary for the claimant to have to swear an oath in order to be believed and to make the respondent have to pay. Only in a case where it is possible that he injured himself as well. But if it's a situation where the claimant could not possibly have injured himself, then he's able to take and win the case, in other words, and take damages from the other party, even without making a shvur, even without having to swear an oath. So the Gemara says, when could you ever find a case of somebody who's exhibits physical damage, and yet it's not possible that he did it to himself? Says the Gemara, V'neichush, let us be concerned, Dilma b'kosel nishchachech, maybe he banged himself on a wall, and that's how he's damaged. Answers the Gemara, Tani Reb Chia, that Reb Chia says we're talking about a specific case of she'olsula neshicha b'gaboy ubein atzile yodov. A person exhibits an injury of a blow between his shoulder blades, specifically a bite on his back between his shoulder blades. That is something which is not physically possible that a person can do to himself. It can only be done by somebody else. Says the Gemara, V'dimla acher ovidle. How do we know that it's Shimon who did it? Maybe a third party did it. Says the Gemara, Deleka acher, we're talking about a case where there is no one else. So the Rambam and the Shulchan Aruch helpfully sum up what comes out from this Gemara, and it goes like this. Reuven comes to Beis Din and he says, I've got a broken leg. And he shows Beis Din his broken leg. He said, who did it? He said, Shimon did it. Shimon comes into Beis Din and Shimon denies it. Under normal circumstances, we have no proof. If you can bring two witnesses that Shimon did it, we're going to find Shimon liable to pay for the damage done. But you've got no two witnesses. So on that, the Mishnah says you can't just make a shavua, swear an oath and win the case. That's not going to help you. Says the Rambam and Shulchan Aruch, but if you go into a room, Reuven and Shimon both go into a room, there's nobody else in the room, and there's no other doors that can go, that lead to the room. So no one else could have gone into the room. We all witness Reuven and Shimon going into the room, and Reuven comes out with a broken leg. Now, Reuven says it was Shimon who broke my leg. Chances are it was Shimon who broke his leg. There is a small possibility that Reuven broke his own leg and is blaming it on Shimon, but it's extremely unlikely. People don't normally break their own legs in order to blame somebody else and find him liable. Nonetheless, we don't have absolute proof. Says the Gemara, says the Rambam, that's the case where the Mishnah says, you're right, we don't have absolute proof, but there is very strong circumstantial evidence. It's not enough to be mechayev you without a shvur, but the Chachamim made a takona, an edict, that if you swear an oath, we will give you the money, we will find Shimon liable, because there is very strong circumstantial evidence. Says the Gemara, but what happens if the circumstantial evidence is not just strong, it's not just overwhelming, it's so compelling that there is no other possibility at all. Reuven and Shimon go into a room, both are well and healthy. Reuven comes out with a bite mark between his own shoulder blades. That's something he could not possibly have done to himself. There is only one explanation, that Shimon did it. Then we have absolute proof, because there is no other possibility. It's not beyond reasonable doubt, it's beyond any possible doubt that it was Shimon who did it. Then Shimon is found to be liable, even in the absence of any clear testimony, and even without Reuven having to be required to swear an oath. So we see already now that it's not so simple when we can use this concept of umdana, of compelling circumstantial evidence. And the Maharik, that's Rabbi Yosef Kolon, who lived in the early 15th century in Germany, gives us a bit of guidance. And he says like this: if we know what happened, the only question is, what is the intention? What is in the mind of the parties? For example, the man who gave away a gift, but only afterwards realized that his son was still alive. Or the Rosh's example of the man who gave all of his property as a free gift to his brother-in-law when the creditor was on the way around to pick up the money. So we know what happens. There was a gift. We've got the clear deed of gifts. The only question is, what's the intention of the person? What's the intention of the parties? Then we are more at liberty to use the circumstances to discern what happened. If any objective observer would come to the reasonable conclusion that the man only gave away all his property because he thought his son was dead, but had he known his son would be alive, he wouldn't have wanted to give it away, we can use that to discern his intentions, even though they were undeclared, and we will void the gift if it turns out that the son at the time was alive all along. However, if we don't know what happened, such as the case of the man who walks into a room, we don't know exactly what happened. We're trying to use the circumstantial evidence not to discern the intentions, but to establish the facts, what actually happened to these people. Then we need stronger evidence. If we've got very compelling evidence, we will allow the claimant to take the damages, but only if he makes a shvur. And even that's only a special takon of the Chachamim in order to ensure that law and order is established and people don't go around beating other people up. But it's an exceptional circumstance. However, even in a case where we're looking to establish the fact, if the evidence is so overwhelming as to be impossible for there to be any other explanation, such as the man who has a bite mark between his shoulder blades, then that is sufficient evidence even to find the person liable without the claimant having to be required to make a shvur. Because that's not testimony anymore, that is knowledge. That's absolute certainty that this is what happened. We don't need testimony when we know for a fact what happens. So again, briefly to sum up where we're holding at the moment, if we know what happened, we want to know what the people were thinking, they had undeclared intentions, we can use umtana, if it's very strong, compelling evidence, circumstantial evidence, what the person was thinking. If it's not so strong, we have the Tosfos and Kiddushin who says it depends. If it's very strong evidence, then the person whose aliyah plans fall apart is entitled to say that he voids the gift, even though he didn't say it clearly at the time. If it's not such clear evidence, then he may be entitled to void the gift if he expressed his intentions, even though he didn't say it as an explicit condition. If it's not at all clear for the circumstances, then he would only be able to void the gift if he explicitly made a condition. But all that, again, is when we know what happened, we're trying to discern the intentions of the parties. But when we don't know what happened and we're trying to establish the facts, we need a higher bar of proof. We need a higher bar of circumstantial evidence. If it's very compelling, it's very unlikely a person would break his own leg. The only other possibility is that it was the Shimon who did it, then we would believe him if the claimant made a shvur and swore an oath in Beis Din to that effect. If the evidence is so overwhelming that it's not possible that there is any other explanation, then that's already the level of knowledge rather than proof. That's a certainty, and Reuven would win the case without any testimony whatsoever. Now let's consider a slightly different category of case. We turn to the Gemara in Ksubas Daf Pei Hey Amud Beis. It's the second source that we have on page 2 of our source sheet. It's a very interesting story. Hahi Itza, there was a woman, the Ichai Vashvor Beidina de Rova. Rova, one of the later Amoraim, had a Beis Din, and a case came before him between two parties. One of the parties, the respondent, was a woman, and the halacha, the psak din was, the award was that she would be exempt from the claim if she made a shavur in the Beis Din. For whatever reason, we don't know what exactly the shavur was, what the case was, but that was the ruling. So Rava said, listen, if you make a shavur, if you swear in Beis Din that you're telling the truth about this, you'll get off, otherwise you have to pay. She was about to make the shavur, but Omralei Bas Rav Chisda, the daughter of Rav Chisda, turned to Rava. Incidentally, Rava actually married the daughter of Rav Chisda. I don't know if this is the one that he married or it was his sister-in-law, but whoever it was, the daughter of Rav Chisda happened to be in the Beis Din, and she wasn't a party to the case. And she turned to Rava and she said, I happen to know this woman, and she's not trustworthy. She's suspect to make a false shvur. I know for a fact that she's made a false shvur in the past, and therefore you can't trust her to swear an oath. It won't help you if she swears an oath because she's liable to lie under oath as well. So Rava said, Rava said, well, in that case, I'm not going to allow her to swear an oath to exempt herself. Rather, I'll turn the oath on the claimant, and I'll say to the claimant, if you're prepared to make an oath that you're telling the truth, if you make that oath, I will find her liable. What do we see from this story? That Rava didn't know who this woman was at all. But Rav Chisda's daughter said to Rava, I know this woman, and I know she can't be trusted to make a shvur. And therefore, Rava adjusted the din and didn't allow her to swear an oath to exempt herself, but rather allowed the claimant to swear an oath that he was telling the truth, or she was telling the truth, and end up winning the case. So the Gemara carries on very interestingly. Zimnin, another time, have a Yosvi Kamei, Rav Papa, Rav Ada bar Masna. Rav Papa and Rav Ada bar Masna, two Talmidim of Rava, were sitting in front of Rava at the Beis Din, and another din Torah came in. Aisu hahish Torah gabe. Two parties came into the Beis Din. One party said to the other one, Shimon owes me £1,000. Shimon denied it. Reuven produced a shtar. He produced a bill of debt signed by two witnesses, which says that Shimon owes me the money. Very strong proof. Normally that would be sufficient to win the case. Says the Gemara, what happened? Amalei of Papa turned to Rava and he said, Yodanabe, the shtar priya here. I happen to know for a fact that that debt has been paid up. I know for a fact I was there when it was paid up. Amalei, so Rava said to Rav Papa, do you have another witness together with you? Or you the only one who was there? Amalei, no. He said, no, I don't have anybody else with me. I'm the only one who was present. Amalei, so Rava said to him, you, sir, Rav Papa, are a witness, but you're only one witness. And the Torah says, in Dinei Mominus, in monetary Dinei Torah, we need two witnesses. So I'm afraid I'm going to have to ignore your testimony. So Rav Papa turned around to Rava, and he said, the last in Torah we were at, a woman was supposed to make an oath. Rav Chisda's daughter told you, I know for a fact that she's not trustworthy. And based on Rav Chisda's daughter's testimony, you accepted it and you made the other person make the shvur rather than her. So why don't you listen to what Rava says when he gives testimony that he knows for a fact in this case that the debt has been paid off? So Rava answers, Bas Rav Chisda kimli begavo, mar lo kimli begavo. The daughter of Chisda, I know her well, and I know that I can absolutely trust her. And if she says she knows for a fact that this woman is suspect and can't be trusted with an oath, then I will believe her. However, you, Rav Papa, I'm afraid to say, I don't know you well enough, said Rava, and therefore I can't rely on you 100%. And therefore, you're no better than an Eid Echad. If you bring along another witness, we'll have two witnesses, and I have to accept the testimony of two witnesses. But if you're only one Eid, it's not going to help you. So Rav Papa himself, the Gemara goes on to say, says that in that case, if I were sitting as a Dayan in a Beis Din, and someone came in with a bill of debt and a claim against somebody else, and someone who I trust 100%, a third party, were to tell me he knows for a fact that the debt has been paid off, if it's someone that I know well and I trust him 100% that he knows what he's talking about, then I would tear up the shtar. I would tear up the bill of the debt. Says the Gemara, well, actually not. Says the Gemara retracts from that. So no, you wouldn't tear up the bill of the debt, but you would say, we need more evidence, we need more proof. The bill of debt is not sufficient because there is cast some doubt as to the validity of the bill of debt. So here we see something very, very interesting. We see that we have a case, a din Torah in front of us. We have no evidence to back up the claims of either party. A third person sitting in the Beis Din who is not a litigant, is not directly related to anybody, says that he or she has testimony which is relevant to the case. If the Dayan trusts that person so much that they're convinced that that person is telling the truth and knows what they're talking about, the Dayan is allowed to take that into account. Not entirely. Rava didn't award the payment to the claimant. Rava said, we won't allow the respondent to get away with exempting herself with an oath. We'll rather turn the oath onto the other party. The claimant will win if he makes an oath. Rava didn't outright make the woman pay. Similarly, Rav Papa says, if there was someone there who testified who I would trust 100%, then I wouldn't tear up the shtar. I wouldn't say, I've accepted this as evidence as true, as good as two witnesses, and I can dismiss the case. No. But I would ask for more testimony. The fact that you've got a bill of debt is not good enough if I have someone I trust 100% who tells me it's been paid up. So we see from this Gemara a very interesting rule, that if a Dayan is sitting in a din Torah and someone gives evidence who's not directly related to the case, who the Dayan trusts 100%, the Dayan may take that into consideration. Not entirely to rule exclusively on that testimony, but he can take that into account when he comes to making the award. Now, you'll be interested to know that the Rambam says, he brings down this halacha l'maisa because it's clear from the Gemara that that is the halacha, says the Rambam, however, and the Rambam is going back over 800 years ago. Nowadays, he says, when the Botei Dinim that we have are unfortunately not as trustworthy as they were in the times of Rava and Rav Papa, and if they are trustworthy, they're not as professional and as knowledgeable as Rav Papa and Rava, we can't allow a Dayan to use this loophole and accept testimony of someone he knows as a fact to be telling the truth and use that in evidence in the Beis Din. And therefore, although the Gemara says in Rav Papa's case and in the daughter of Chisda's case that the Dayan was allowed to use such testimony, nowadays no Beis Din is allowed to use that type of testimony. So again, if we have an absolute umdana, a clear presumption, we can discern a person's intention. If we don't know the facts and we want to know what happened, we need either two witnesses or an overwhelming presumption. If we have a third party who we trust 100%, who he wants to give evidence in the Beis Din, although in the times of the Gemara, some weight could have been given to that, nowadays the Beis Din cannot use that, and that won't be helpful enough to actually have a significant effect on the award of the Dayan. Let's now go briefly to the last quote that we have here on our source sheet. This is a Gemara in Baba Basra Daf Nun Ches Amud Aleph. A very interesting story. Hahu Gavra, there was a man, to Shoma Ledvisu, he overheard his wife talking to his daughter. And the wife said something quite shocking to the daughter. The wife said to the daughter, to Ka'omur Lebrato, she said to her daughter, Amai lo tzunio be'isura. When you are being unfaithful to your husband, you should do it very secretly. Hach itza, that woman, she said, talking about herself, me, Asora boni isla, I have 10 children, 10 sons, V'les lech me'avuch el achad. But only one of them, your father, is the true father of this child. So this man overheard his wife admitting to his daughter that the 10 sons that she bore to her husband are actually, only one of them is actually his son, and all the others are sons of somebody else. And she'd committed adultery so often, she was actually advising her daughter that when you want to do it, you should do it secretly. The man was shocked to discover that of the 10 sons that he thought were his, only one of them was his, and the other 9 actually weren't his. In fact, they were mamzerim to all intents and purposes. Well, what happened next? Sometime afterwards, the man passed away. Ki shochiv, when he died, Amalahu, he said to the people present, Kol nachosai, I hereby bequeath all my property, lechad bara, to only one son, the one genuine son who is my son. I give him all of my property. I bequeath to him everything that I own. The trouble was, no one knew which one it was. Which is the son is actually his son, and who are the other 9 who are not actually from him at all, and obviously don't inherit him because they're not related to him. So they went to the Beis, all 10 sons, and they said, we don't know what to do. The man's dead. He didn't know which son is the real son. We know only one of us is the real son. None of us know which one it is. He's bequeathed everything he owns to the one genuine son. What should we do? So they went to the Beis of Rabbi Benoah. Lo yodin lahaminayu. They didn't know which one it was. Also, lekamei Rabbi Benoah. They came in front of Rabbi Benoah, who was on the Amoraim from the Gemara. So Rabbi Benoah said, Omalahu, he said to them, I don't know which one is the real one. Why don't you go and ask your father? Zilu, go. Chavutu kivrot avuchon. Go, take sticks, go to your father's grave, bang on the grave with the sticks. Ad dekoy megali lechu. Bang on his grave with sticks until he appears to you and tells you which of you is the genuine son. Now that he's an Olam HaEmes, he's probably discovered which is the real one. Go and bang on his grave and ask him. So Rabbi Benoah said that's what they should do. So off they went. Oslu Kulu. They all went off to bang on his grave. Hahu Debrei Hava, but the genuine son, Lo Ozel, he didn't go. Amalu, they came back and they said to Rabbi Benoah, we banged on the grave, and what do you think happened? Absolutely nothing. Not a sound. So Rabbi Benoah said to him, did you all go? They said, all of us went. Are you sure all of you went? They said, no, actually 9 of us went, but one of them didn't want to go. Rabbi Benoah said, Kulu nixi dahai ozlu. All of the man's property should be given to that son. He's the true son. How do I know he's the son? Because he didn't have the heart to go and bang on the grave. All the others, in order to get the money, in order to get the Yerusha, were prepared to go to the father's grave and bang on it with a stick and say, Dad, come out and tell us which one is the son. One son said, it's pasnished. It's not right. I can't do that to my father. He must be the real son. There's something deep inside him which he might not even recognize himself, which indicates to me that he is the genuine son. Rabbi Benoah gave everything to him.
So why do we believe her to start with?
Sorry?
Why did we believe her to start with?
I don't know. We don't necessarily believe her, but the man believed her. The husband himself believed her. And therefore he said that's what he wanted. He's going to give it only to one son. We don't necessarily know for sure that that's the case. But that was the man's final will and testament to give it to only one son. And assuming that only one son was the real one, we had to find out who it was. This is how Rabbi Benoah found out who it was. Now, you might be thinking of a similar idea that preceded Rabbi Benoah, which the Alshich in a tshuva, in a response from the Maram Alshich, actually refers to. And that's the famous case of Shlomo HaMelech. Shlomo HaMelech, everybody knows, the Novi says, the Melachim, it says, the 2 women came to him holding a single baby. They both had a baby, and one of the babies had died during the night. Each woman said that the live baby belongs to me, and it's the other one who died. So Shlomo HaMelech said, bring a sword, cut the baby in half, give half to one mother and half to the other mother. So one of the women said, yes, go ahead and cut. Gam li, gam loch lo yeh. We'll have half each. And the other woman said, no, do me a favor, just give it to the other woman. I'd rather you give it to the other woman than cut the baby in half. Says Shlomo HaMelech, she is the true mother because she has compassion on the child, whereas the other mother didn't have any compassion on the child. What do we see from that case? That sometimes the Dayan can base his decision on a feeling. It's not a proof. It's not circumstantial evidence. It's not overwhelming circumstantial evidence at all. It's a sort of a hunch. It's a good shtick. It's a way of trying to discern it. Is it absolute? Surely not. There's another famous case that they say about a young man who traveled from one town to another for a shidduch that was proposed for him. And when he got off at the station, a woman came over to him and said, "You're the young fellow who's supposed to meet my daughter and get married to my daughter." So he said, "Yes, I'm the young man." They were about to go, and another woman comes over to him and says, "You're the young man who's supposed to meet my daughter and marry my daughter." So he looked at one and he looked at the other, and this was going back a couple of 100 years ago when he didn't have any other information. And he said, "I don't know which one is the one who's the mother of the daughter I'm supposed to meet. So let's go to the town rabbi." So they went to the town rabbi, and this woman said, "He's supposed to marry my daughter," and the other woman said, "He's supposed to marry my daughter." So the rabbi said, "I'll tell you what we'll do. We'll do it like Shlomo HaMelech. Bring a sword. We'll cut the man in half, and you can have one half, and you can have the other half." And one woman said, no, don't cut him in half. Just let him marry the other woman's daughter. And the other woman said, no, cut him in half. So the rabbi asked, she's the real mother-in-law. She's the real shviga. That's the way of knowing who it is. Well, Kaponim, what do we see from the case of Shlomo HaMelech, and what do we see from the case of Rabbi Benor? Sometimes the Beis Din can use what is, in reality, if you like, flimsy circumstantial evidence. It's not absolute proof. It's a tchusha, it's a feeling. Near Madroim, it looks like this person is the right one. How comes, as we've discussed at length, you really need either two witnesses or very strong, compelling circumstantial evidence? Why in these cases do we find that the Dayan was able to use this type of idea, this type of svara, this type of feeling to rule the case? And I think there's two reasons why these are exceptions. Firstly, there is nobody holding on to the money. In virtually every case which comes to Beis Din, Reuven is asking money from Shimon. To take money away from somebody else, you've got to have proof. Proof has to be two witnesses. If you don't have two witnesses, it's got to be very strong, compelling circumstantial evidence. But in the case where no one's got the money, the man has died and the money's sitting in the Beis Din and everybody's claiming it, but no one's actually holding on to it. Or in the case of Shlomo HaMelech, where there's a baby in the middle, no one's holding more than the other, then perhaps these are the type of circumstances where the Dayan is permitted to use his ingenuity to try and work out who is the real mother and who is the real son. And the other point is that in both of these cases, there is really no other option. In most cases of a din Torah, if you haven't proved your case, that's the end. The case is dismissed. In the case of Rabbi Benor, and even more so in the case of Shlomo HaMelech, you can't simply say, well, we don't know, there's no proof, and therefore we'll leave it as it is. The baby is at the moment being held by two mothers. Something has to happen. Here the Dayan has no choice. There is no two witnesses. There might not even be an umdana. There's no overwhelming presumption. But there's no other choice. We have to decide either one or the other. Rather than toss a coin in such a case, we'll use our ingenuity to try and work out if we can find any type of other indication that this one is the true mother or this one is the true son in the case of Rabbi Benor. So very briefly to sum up what we've learned tonight, we've learned quite a bit. In Dinei Torah, in a Din Torah arbitration, when someone makes a claim against somebody else, you need, in order to prove your case, two kosher witnesses in order to prove absolutely your case. One witness is usually not sufficient. However, if we know what happened, but we're trying to work out what your intention was, then if there's a very strong presumption that we can look at the circumstances, you were going to go to Eretz Yisrael, and that's why you sold it, or you thought the son, his only heir had passed away, and that's why he gave away all his property. Even if he didn't explicitly express a condition, we can discern his intentions, we can use that to possibly void a gift, because it would be clear to any objective observer what is going on here. However, to establish a fact, to establish what happened, did anybody damage this other person? Was it him or was it not him? Then we need much more than that. We need overwhelming presumption in order to allow the claimant to win the case. And even then, it's only a special takona of the chachomim, and only if the claimant is prepared to swear an oath that he's telling the truth. However, if the evidence is so overwhelming that it's not possible that anything else could have happened, such as the bite mark between the shoulder blades, then that is already a level of as good as having two witnesses. It's even better because we know for a fact what happened. It couldn't have been anything else. That's enough in a din Torah. Then we have this interesting case of the daughter of Chisda and Rav Papa, where in the times of the Gemara, a Dayan was permitted to rely on the evidence of a third party who the Dayan knew to be absolutely truthful and knew exactly what they were saying, but that doesn't apply in Beis Din nowadays. And then we have these interesting cases of Shlomo Melech and the case of Rabbi Banal, where the Dayan used an ingenious circumstantial proof without actually being compelling or absolutely convincing, but to give an idea of discerning who was telling the truth and who wasn't. And we're suggesting that that's only in cases like this, where first of all, no one is actually muhsuk, no one's holding on to the money, and second of all, something must be done. It's not enough for the Beis Din or the Dayan to simply say there's no proof, we'll leave things as they are. In such a case, in the absence of any other option, you can use even this type of circumstantial evidence in order to establish the case and to make an award in the Beis Din. Okay, I'm happy for the next few minutes if anybody wants to ask any questions.
Thank you, Dayan Hool. Yeah, if anyone has any questions, please just take yourselves off mute. Otherwise, I'll ask a quick one. I'm just interested how, in kind of modern Beis Din, how commonly cases would be settled via circumstantial evidence versus more classic star or the two witnesses. Does it come up a lot?
It can happen. The truth is that in many cases in the din Torah, probably most cases, the dispute is not about what actually happened. There's not that often a dispute of fact. It's unusual that one person comes in and said this happened, and the other party said no, this happened. What far more common is for a dispute to revolve around points of view. I understood that we'd agreed to this, and the other party understood we'd agreed to that. Or interpretation of a contract where there's a clause there which one party says interprets one way and the other party interprets another way, or sometimes a question of what happened where it depends on the memory of the parties. We made an agreement 3 or 4 or 5 years ago, and I distinctly remember saying like this, and he distinctly remembers saying like that. And in those cases, we don't usually have any evidence or circumstantial evidence either. But it can happen. There are cases where again, we know what happened and we want to discern. There was a very interesting case in the Beis Din when I was in Eretz Yisrael. I didn't actually sit on the case, but I was on the Beis Din sitting on a different case, and I heard discussing this case. Someone had donated to Rabbi Elyashiv a few years before Rabbi Elyashiv passed away. Someone donated a machzor for Rosh Hashanah and Yom Kippur for Rabbi Elyashiv to use. A very large machzor in very large print, because Rabbi Elyashiv was quite advanced in age at the time, and it was beautifully leather bound and it had gold leaf on the front. And then after Rabbi Elyashiv passed away, the fellow who gave it went into the house and took it back again. And then Rabbi Elyashiv's heirs came along to the Beis Din and said, this fellow gave a gift to Rabbi Elyashiv, and he can't just take it back. And we want it back again. And the donor said, well, it's true I gave a gift, but I had only intended to lend it to Rabbi Elyashiv. I didn't actually intend to give it to him as a gift. The whole idea was that I would let him use my machzor and then claim it back. And then I could tell everybody that I got Rabbi Elyashiv's machzor. I didn't just want to give it as a free gift. So there was a quite extensive halachic debate for various reasons about what to do with such halacha. But one of the issues that came up was, does it make sense to say that? Is it likely that a person would give a gift to an important person, such as Rabbi Elyashiv Gadol Hador, on the understanding that he'd get it back as soon as Rabbi Elyashiv passed away? Or is that something which is clear to any objective observer, is not what one would normally have expected? And I have to say that when I heard about the case, my first instinct was to say that's ridiculous. If you give a gift, you normally have given it away entirely. If you don't specify at the time you're lending it and you give it as a gift, presumably you're not going to get it back. To come along afterwards and say it's clear to everybody that I only lent it is not a presumption that I would have made. However, asking around in Eretz Yisrael amongst the more Yeshiva Sha'olam, and particularly amongst the Hasidic Sha'olam, it turns out there's a very large body of opinion in the general public who understands not like that, and actually understands that, yes, it's quite clear to our objective view that anyone who gives a gift like that to a important Rebbe or a big Godel is only lending it and assumes to get it back afterwards. If he didn't specify that it's a gift, then surely he only meant to lend it. So sometimes, again, the case wasn't actually ruled upon based on this subject at all. Actually, it was based. There were other elements to the case, but that was an interesting application, possibly of this. The difficulty there was to establish what is the umdana. What is the overall presumption? And in that case, it appeared there was actually a debate amongst the general public, certainly the limited general public that we surveyed, about what most people think is obviously the intention of a person under such circumstances.
Thank you. Any other questions before we wrap up?
Yes, out of curiosity and slightly off topic, have the Beis team been inhibited by COVID and people not being able to physically come into the Beis in terms of the halachic necessities for the Beis to sit?
Yes, so you're correct that as far as the strict letter of the law is concerned, Beis Din have to sit in person, and the parties have to appear in person in front of the Beis Din, and the witnesses who want to testify have to appear in person in front of the Beis Din. However, the halacha says that is the default position for a din Torah. Nonetheless, the parties to a din Torah are perfectly entitled to vary those rules if they want. And therefore, again, a Beis Din is normally a tribunal of 3 Dayanim, but if both parties agree that they'll be arbitrated and adjudicated by a single Dayan, and they sign on that at the outset, that's fine. Another halacha, Beis Din al-pi halacha mikra din can't sit at night. At least the beginning of the din Torah has to be during the day. If you continue on into the night, Beis Din is not allowed to begin a case at night. However, it's very common nowadays, especially in the winter, for cases to begin late afternoon when it's already dark. The basis for that is, again, if the parties agree to it, then it's absolutely fine. They can vary the rules. And therefore, during the lockdown, and even now, actually, when the lockdown has been quite more or less eased, our Beis Din offered a service whereby if parties want to have a din Torah, we're prepared to hear the din Torah via Zoom, where either the Dayanim will sit in the Beis Din and the 2 parties appear via Zoom, or the Dayanim themselves appear via Zoom together with the parties. And again, if both parties agree to that, it's fine. If either party insists that he wants to appear in person, and we had a case like that where the parties were from, both parties actually were from Australia, and they intended coming for a din Torah, but the din Torah was had to be postponed because of COVID. One of the parties said, I'm prepared to appear in a Beis Din from Australia via Zoom. But the other party said, I'm not prepared to, I'm going to wait, I insist on waiting until I can come in person and present my case. And he has a right to do that. We can't stop him. We offer the service if people want to appear in the Beis Din virtually via Zoom. And some people do take it up. We had quite a few cases via Zoom. We had 1 or 2 cases where one party appeared in person, whereas the other party appeared on Zoom. We had a couple of cases where both parties appeared by Zoom. And as the technology improves, it actually works quite well. It's not quite the same as having the parties in front of you in the Beis Din. Sometimes you can discernibly notice someone whispering to the litigant in the background off screen, which is not helpful. But by and large, it actually did work quite well. And again, the service is available for if anybody wants it.
Can I ask a question?
Sure.
Somebody who has a high street store and he wants to sell up. He wants to give up his going concern. He wants to sell up, and he's telling the fellow who's buying it, I'm not doing too well. There's no point carrying on. We're selling. He made a proper kinyan and everything. And within a year, he has to leave, but it's sold properly. After a year, things picked up. And he said, sorry, things have picked up. I don't want to sell.
Okay, so it's very difficult to tell you absolute rules on individual circumstances, individual cases. You have to look at the case and all the other circumstances around it. But I don't think in that particular case we'd have a very strong case, because it's not an overwhelming presumption at all. People change their businesses. and sell businesses, not necessarily because this one is only because it's doing badly. And had he known it would get better, it would have changed the situation. Sometimes he might genuinely want to move on to another business. And anything where there's a long time factor involved, he's allowed to stay on for a year. So at the time he makes the sale, he knows very well that things can change over the course of a year. So that's understood that if you don't make a condition explicit in that case, since we both know that things can easily change over the year, and you didn't make a condition on that, there wouldn't be, I don't think, in such a case, an overwhelming presumption. Similarly, Tosfos thinks Subba says, if someone sells an animal to somebody else and the person checks it and it turns out it's treif inside and he can't eat it, he can't ask for his money back and say, had I known it was treif, I would never have bought it. It's probably true, had you known it was treif, you would never have bought it. But on the other hand, you also knew that you couldn't possibly know if it was treif until you shechted it, and so did I. So you knew you were taking a chance. So whenever anybody buys an animal, they're taking a chance that maybe you won't be able to use it. Maybe the animal will drop dead tomorrow of natural causes, and not because it's ill or there's anything wrong with it, but because it just reached the end of its life. So that type of thing is to try and establish that there's an overwhelming presumption of circumstantial evidence that was his intention. It would not probably apply in such a case. I can't imagine that any Dayan would say that any objective observer would accept here that he clearly only intended to sell because he knew that he was convinced that it would never get better. That's probably not correct.
Good evening, Dayan Hool. Just wanted to ask you something. This is Emmanuel Dayan speaking. Just wanted to ask you something about the case of Shlomo HaMelech.
Yes.
Did you say that's circumstantial evidence? If the woman who was not the right mother, in the end of the day said, no, chop him up, is that not convincing evidence? Which mother would...
Personally, I'm not convinced. I have to tell you, it's very good, and it's very good. And if you have one mother saying yes and one mother saying no, and now that we all know the story, then it's very good. But if you're telling me, does it reach the level of umdana? Does it reach the level of it must be? It's not. It must be. It might be that she's not telling that she's not the real mother, but still has more rachmanis than the other mother. It might be that the other woman is telling the truth, but she happens to be a particularly hard-hearted person, and she'd rather have the animal, have the baby cut up. It's not absolute proof. It's very good. It's a good shtick, but it certainly doesn't rise to the level of the testimony of two witnesses, and very doubtful whether it was rise to the level of an umdana. But I'm happy if you think that it is. I have no problem with that. It could be. But the Alshich himself used that as a source for Rabbi Benar's ruling. And Rabbi Benar's ruling is clearly a lot more subjective and not again, it's good and it's a good proof and everything. Is it absolute proof? Surely not. But Alshich certainly felt that it was similar to Shlomo HaMelech's case. I'm happy to accept that Shlomo HaMelech's case may be more compelling evidence than Rabbi Benar's case. That's very possible.
Thank you.
Well, thank you very much, Dayan Hool, for a very interesting share. Next week, we will, please God, be joined by Rabbi Schiff at 8:15, but we're just confirming the details. Thank you very much, everyone, for joining, and thank you again, Dayan Hool, for
Thank you all for joining.
Thank you. Thank you. Aaron, is there a recording of this share?
Yes, there should be.
Okay.